Hey everybody, welcome back to the channel today. It is another glorious occasion. We have gotten another victory in court in the form of a preliminary injunction without the added effect of a stay this time. But before we get into that today, I just want to remind everybody that it is helping. Please be sure to like, share, and subscribe to these videos. Hit that little notification bell so that when breaking news like this happens, it's on your doorstep when it happens. But let's get into this today. It's just going to be me, no guests on this one. This is going to be a down and dirty, quick update video. There will be a little bit longer video to follow as we break it down with one of the attorneys. But for now, we needed to express this. We have gotten a preliminary injunction on the lawsuit B&L Productions v. Newsom. If you haven't heard about this one in a while, it's because there hasn't been much movement on this one in a while, but we did get a preliminary injunction today without a stay that would basically grant us the right of having gun shows again in the state of California, with the exception of the Del Mar Fairgrounds. And I'll tell you why right here. This is where there might be a little bit of confusion that I want to make sure everybody understands. There are two lawsuits out there right now that are titled B&L Productions v. Newsom. The first one was filed against a piece of legislation that is AB 893 from a couple of years ago. That one was legislation that specifically forbade the sales of firearms on the Del Mar Fairgrounds. That lawsuit, we did get an unfavorable ruling at the federal district court, has been appealed to the Ninth Circuit. But this one that we got the injunction filed on today, which was filed in a federal district court in Orange County, specifically enjoins Senate Bill 264 and Senate Bill 915 from a couple of years ago. This was Senator Minn's Bill 264 that prohibited firearms sales on the Orange County fairgrounds, and then it was 915 that forbade it on all state-owned property. Those two have been enjoined in this lawsuit, and we do have an injunction that would render it legal now for gun shows to take place on these properties. Jacob, why don't you go ahead and pull up the text from the actual decision? I wanted to share this. So the California legislature recently enacted two statutes that effectively ban guns that would be from Senate Bill 264 and Senate Bill 915 that effectively ban gun shows at the Orange County Fairgrounds and more broadly on state-owned property. Plaintiffs moved for a preliminary injunction. Plaintiffs argued that the statutes at issue infringe both their First Amendment freedom of speech rights in a public forum and their Second Amendment rights to keep and bear arms. After reviewing the parties' extensive briefings and conducting a hearing on the motion, the court concludes that the plaintiffs have established that they are likely to succeed on the merits of their constitutional claims and that they have satisfied the other requirements for injunctive relief. Accordingly, plaintiffs' motion is granted. Defendants are preliminarily enjoined and restrained from enforcing the two statutes at issue. So again, this stops these two laws from being enforced, which means we will be able to have gun shows on state-owned properties. Again, this is for now. Whether or not the state is going to appeal this to the Ninth Circuit remains to be seen. But for all of those comments that we've received in prior videos saying that, these injunctions don't really mean anything if they're going to be stayed, I want to read this from the decision. Jacob, if you can pull it up right now, because this injunction did not come with a stay on it. Let me read this here. At the hearing of the motion, defendants made for the first time a request that the court stay any preliminary injunction until defendants could file an appeal. Here, defendants' oral motion to stay fails because defendants satisfy none of the requirements established by the Ninth Circuit in index newspapers. As discussed above, plaintiffs, not defendants, have shown a likelihood of success on the merits of plaintiffs' constitutional claims. Defendants also have not demonstrated irreparable injury, although crimes committed with illegal firearms are unquestionably a serious concern. Defendants have not shown that there is an appreciably higher risk of illegal gun sales occurring at gun shows than there is at brick-and-mortar stores in California. Accordingly, defendant's oral request to stay this court's order pending appeal is denied. That's right. So similarly, this could be similar to something that we saw in Freedom Week, where you have a gap, whether it's a week or so from the time that this decision comes down to where it gets appealed and potentially a stay gets put on this injunction by the Ninth Circuit. But as it stands now, there is no stay on this injunction. And furthermore, this order actually also ordered the fairgrounds in Orange County to send possible dates for shows to B&L Productions. So this is something that is looking like it's going to move forward. And I also wanted to draw some attention to something that they wrote in here. If I can go back to this. Defendants have not shown that there is an appreciably higher risk of illegal gun sales occurring at gun shows than there is at brick and mortar stores. Does this not, kind of bust the myth of any sort of gun show loophole? They're trying to make these claims that gun shows are a way for criminals to get guns that they wouldn't in other ways be able to get them. We've come out in videos, and I've talked to Rick about this. I've talked to our previous legislative director about this. We have sent request after request to law enforcement to give us any sort of information or indication that these sorts of things are happening at gun shows. And I'm talking about dozens of requests. And they have never been able to provide anything here. And in this forum, when the state would most appropriately be able to put forth that data and those statistics to prove that they are correct in banning gun shows on state grounds, they couldn't do it, and they didn't do it. So here we have a judge who is saying that you can't and you haven't proven to me that there is any higher risk of these things happening at gun shows that happen at brick and mortar stores. That is now a statement of record, and I mean, we would argue it's always been a statement of fact, but that is definitely a great nugget that's coming out of these cases. Like I said at the beginning, we are going to continue to follow this one along to see whether or not it gets appealed to the Ninth Circuit. And as we do that, we are going to come with a video that dives into this lawsuit and this decision a little bit more deeply. I'll have the link in the description to the opinion if you want to read it for yourself. It's another great one. So be sure to be on the lookout for that. And we appreciate you guys coming along for the ride. Thanks, guys. We'll see you on the next one.